Welcome, everybody, to Beyond the Bar, Adventures in Law. Today we have two wonderful guests, Jeffrey J.K., Dinyar MARZBAN. I have my dream team on the show today, and one of the highlights of my career is to have you both here. Jeffrey K. is managing partner of Farris, as you all know, and Mr. MARZBAN is the godfather of Jenkins, MARZBAN, and Logan. I'm sure you all know these two. If you haven't been opposing counsel or on the same side as either of them, you haven't enjoyed the highest level of practicing law. Smart, tough, polite, reasonable, fair, courteous, combined with hopefully some humor we'll see today too. These people embody the professional code of conduct. Jeffrey K. came to Vancouver from Winnipeg. He initially did not want to practice family law because, and I quote, "I didn't want to be surrounded by piles of documents." Good luck with that, Mr. K. Martindale Hubbell has awarded Jeffrey J.K. a preeminent 5 out of 5 peer rating year after year. And when somebody asked him, Mr. K here, the song that embodies the practice of family law, he said, "Help" by the Beatles. Dinyar's done it all.
Can we just stop now?
Sure, okay. Dinyar's done it all. Editor of the Family Law Sourcebook, Access Pro Bono Volunteer, Rise Women's Legal Center, etc. And he's been named a Family Law Lawyer of the Year on a number of occasions. Do either of you recall what inspired you to do what we do, family law?
We'll always start with you because you're senior.
I'm senior, but I'm not older.
Yeah. Okay.
I wanted to help people and have a result. So I felt by doing family law, I would be solving problems and I could see the result fairly quickly after becoming engaged in a project. So client in, problem solved, client out. That's what I think I was hoping for when I started 42 years ago. It hasn't always worked that way, but that was my early aspiration.
Dinyar, do you recall?
Yeah.
Remember your inspiration?
Oh, yes, very much so. So I was at law school at Dalhousie, and they had a legal aid clinic, which was your get out of class pass for one term. You could go work at the legal aid clinic. So I signed up for that. It was about 50% family law, 50% criminal. And you got your own clients. They sort of threw you in the deep end. And I just enjoyed it. I liked the personal contact with people. I liked trying to figure out solutions to their problems inside and outside court. And mostly it was, I really felt, because of the client contact and the personal stories, that you actually can help people.
You know, I was going to say growing up with you two, but growing up in law with you both had amazing principals and mentors. Can you tell people that are watching some of the important things that were passed on to you that you'd like to pass on to some of the younger lawyers watching the show?
So Bill Berardino, this is when I was doing more than family law, other areas as well. He was my mentor. He was a civil litigator at what is now Faskins. And he took me under his wing. And he told me one day, I was talking to him about a case. I came in and I was getting all jacked up about it, and this is going to happen. And he looked at me and he said, "You know what, Dinyar, you've got to work on being like this. Right now, you're like this." So I try and remind myself.
Okay. Mr. K?
My mentors were not family law lawyers. And I would say that my two were Jack Giles and Peter Butler of our firm. And they were completely different lawyers. Jack was the consummate British barrister. He looked like he was right out of central casting. He was incredibly organized, incredibly detailed, and went into court, I think Chief Justice McEachern said, holding 5 aces. And Peter Butler was the exact opposite. He was sort of Peter Falk. He was unkept. He appeared disorganized, papers flying everywhere, but he was incredibly shrewd and understood human dynamics at a very high level. So those were, along with Mr. MARZBAN, my two mentors.
Okay. Dinyar, over the years, you've spoken to me on many occasions about client management, which in family law is crucial. Can you tell the audience what client management should entail?
Well, I think what you want with your clients is each one of your clients should feel like they are the most important client you have. That's the way they should feel. And you can make them feel that way. And the starting point with client management for me, Jeff, is first meeting. And I don't think a lot of lawyers do this. I've spoken about this at previous CLEs, so if this is repetitious to some people, I apologize. But I feel really strongly in terms of advice for particularly younger lawyers. So first meeting, communication. At the end of the meeting, let's assume you've accepted the retainer, everything's all set up, you're going forward. You tell them, okay, this is how we're going to communicate. If you phone me, it will go into voicemail. And the reason for that is, if I didn't have you the call forward on right now, we would have been interrupted 5 times during this meeting we had. So I can't do that. So you're welcome to phone, leave a message, I'll get back to you. But if you're leaving a message asking 3 or 4 questions, we need to speak. Don't phone me, just phone my assistant and say, I need to speak to Dinyar. When can I speak to her next or him next? And they'll go into my calendar, they'll give you an appointment, they'll say, do you want it on the phone, in person, 30 minutes, 2 hours, what do you want? And you will be able to speak to me at that time, and I will be prepared because it'll be in my calendar. So you can phone and leave a message, but honestly, it's better unless it's a very discrete question, one answer, that sort of thing. Same thing with email. Send me an email if you want to, but unless it's 1 or 2 questions with a pretty straightforward answer, we need to talk, just contact my assistant. You'll have my undivided attention at the time I call, and you'll never, ever feel that you weren't able to speak to me. When you do that, you eliminate a lot of really useless contact, and then you'll have a client who appreciates that when they want to talk to you, they'll be able to talk to you.
Does your hourly rate go up for each extra question?
No, I kind of do. I thought about that, but I let it go.
Okay. Jeffrey K., what are the most important aspects of client management for you in your practice?
I think it's managing expectations. I think early on, you should be able to give a client a sense of what they should expect, like what the issues are, or what the parameters for resolution might be, what is not possible, what is unrealistic, and what they should generally expect in terms of result. And, some family law cases are complicated, but I've always felt that there's probably 7 key questions you have to ask a client to get a sense of what the case is about. And managing the expectations of the client is very, very important. And in terms of just commenting on what Dinyar said in terms of dealing with clients, I think the most important thing myself, and this has to be sincere, is to let the client know that you truly care about their problems, that you are vested, that you want to help, that you can help, and that you're concerned about the outcome. I think that's the most important thing that you can communicate to a client. And clients will sense that. If you immediately start talking about your hourly rate, retainers, they're going to lose interest. They want to know that you're there for them, and you have to be there for them or you're not going to be successful.
Yeah. And Jeffrey K., how do you deal with clients whose views are unreasonable or unsustainable in our world of family law?
Well, I think you can do 2 things. One, you give your best advice, saying, I think that's an unrealistic outcome that you're seeking. I think this is more realistic. You can follow instructions as long as they're, ethical, that what you're being asked to do is ethical, but you have to be able to communicate with your client that you don't think that's a reasonable outcome. And the other thing that I think is important in family law or in any retainer, you can't be afraid to part company with your client. And it's harder when you're younger and starting out and you want the work. But if you get a sense that you and your client are not communicating, you're not ad idem, there's a lack of confidence or there's a gap, you have to be confident enough to part company and say, there's lots of other lawyers out there who can help you. I don't think we're a good fit. I'll pass your file on to another lawyer. Just let me know who. You can't be afraid to do that.
Okay.
So Jeff, on that, your mentor, Ed Mortimer, told me years ago when I was a very young lawyer, one of the best pieces of advice I ever got, he told me, he said, Dinyar,
to go for lunch for 2 hours every day?
No, it was a little more serious than that.
Yeah, okay.
He said, Dinyar, there's some people you just can't help. And the sooner you realize that, it's better for you and it's better for them.
Okay. I'm sure both of you have had your share of difficult clients. And there's a lot of young lawyers out there who have difficult clients. Any tips on how to deal with difficult people?
Well, if they're difficult, but not in the departure lounge as Jeff has suggested, sure, there are several ways to deal with that. One is communication. You'll have some clients that are difficult in the sense that they want to talk to you all the time. There's something every day coming up. So one of the ways I've dealt with that is I've told them, look, this is what we're going to do. I will put a phone call with you in my calendar every week, once a week. You pick the day and the time, and I'll have you there, and you save up your questions, and we'll talk about all of them in that one session. And if you don't have anything to talk about, phone my assistant and cancel it. So I had a few clients I did that with, and they took me up on it, and it worked pretty well, and wouldn't you know it, after a while, it just kind of calmed down, and they kept canceling those. And then once in a while, they would phone about stuff, but most of the time we were keeping them informed. So that's one way of dealing with that. Otherwise, if you're talking about somebody with a personality issue, that's why you're paid the big bucks. You just have to do your best with it and put up with it, and not all clients are going to be perfect, and not all clients are going to be appreciative.
You agree?
I do agree. I've always tried to, as best I could, restrict the number of clients that I took on. I think lawyers are sort of like, waiters at a restaurant. If you've got 5 tables that you're serving, you can do a good job. If you've got 10 tables, you're spilling water on everyone. So I've always tried to manage the volume. And there's no panacea for dealing with a difficult client. I think that, patience and direct, straightforward responses to questions are the way to go. Clients ask you a question, you give them a direct, straightforward response, move on to the next question. I found that helpful.
We've spoken over the years too about practice management, organizing your practice to reduce stress. One way to do it is what you did years ago. I would phone Dinyar in the early afternoon, and I'd tell his assistant I wanted to speak to him, and she would say, he's at a movie. Okay, good way to reduce stress. Next time I'd phone, and I'd say, I'd like to speak to Dinyar. I have to talk to him about something. And his assistant would say, he's on Granville Street at El Furniture Taco Warehouse. I go, okay, well, he knows how to reduce stress. He's not denying any.
I remember the first one. I don't remember the second one.
All right. What do you think's the biggest challenge with respect to stress, and how have you dealt with it apart to going Granville Street and movies?
Okay. I think like most lawyers, we just kind of accept that it's just part of the job and that you can't really get away from it. And to some degree, that's true. But it took me a long time to actually think that there's got to be something I can do to make things a little bit better on the stress level. And we're talking about 20 years ago when I came into the office one day. I remember thinking, my practice is great. I've got terrific clients, good work, all of it's good work. The firm's doing well. I'm doing great. I can't stand being here. And what I realized was it was just, I couldn't handle the feeling of constant chaos. So I thought about it. And I made some changes. And I thought the chaos, the number one cause of it is constant interruption. right? Constant interruption. So you have to manage that. So there's several ways of doing that. So the first one I've already talked about not answering the phone all day while you're trying to do something else, right? You're a lawyer, not a call center, right? So yeah, right? But then the other things I thought about were that these constant beepings that we have now, right? So calendar alert, right? Text alerts on your phone, all of those things, that's like trying to work with somebody sticking their finger in your ear every 30 seconds. Honestly, that's what it feels like. And you don't realize it, but it increases your stress level because it takes you off what you're doing all the time. So I'd say calendar alerts on the calendar on your computer, completely useless, right? It's completely useless. I'll tell you a better way to deal with making sure that you don't miss something, but calendar alerts, completely useless. Take that beep off, take the text beep off, take all those beeps off. Nothing bad's going to happen. What's going to happen is your mind will get calmed down a bit. Now, instead of the calendar alert, on your phone, set an alarm for whenever you're supposed to be doing something. That alarm will go off, and when it goes off, it won't shut off until you shut it off. So calendar alert, it pops up on your screen, it goes beep once, you're down the hall having coffee, completely forget about it, right? Your phone's going to be ringing. So I do that the night before, in the evening for my next day. I look at my phone, I look at what the appointments are, and I set an alarm for 5 minutes before each one, whether it's a phone call, a meeting, or time to leave for something like that.
I find this stressful.
And I found it worked great.
I find this stressful.
The other thing is emails. I make a practice now. I don't send emails after hours or on the weekends unless I want an answer back after hours or on the weekend. So unless you want that coming back to you, don't send it then. Draft it, save it as a draft, and I have a 9 o'clock appointment in my calendar every morning that says send draft emails. So I get up in the morning, first thing I see on the calendar is draft emails. I look at those and I send them out. So I've got a bunch more, but I think I'm probably taking up too much time, so let's move on.
Jeff K., I've known you for...
My response would be much simpler than that.
I've known you for a lot of years. And
40
I can
years.
honestly say I have never seen you stressed.
True.
Dinyar's response to that question made me stressed.
Okay. Do you get stressed or you just hide it or what?
I'm going to say two things about managing stress. One is what I tried to do, and I've actually mentioned this to Dinyar, I mentioned this to another very, very good family lawyer, Paul Dakin. I would see clients twice a day. One client at 10, one client at 1:30. That was it. So you get in the morning, you have a chance to do things, you see a client at 10, you have a chance to do things after, you have lunch, you see a client at 1:30. I manage my practice that way. But I'll say this, doing trial work and doing family law trial work is extremely stressful. It's an extremely hard way to make a living. Being in trial for a 10-day family law trial is hard work. You're working hard to get ready. You're working long days when you're in the trial. And then when you come back at the end of a trial day, you've got 25 messages from 25 other clients who want your time. And as tired you are as at the end of the trial day, having to get ready for the next day to deal with those 25 other clients in between is stressful. And then, lo and behold, when you surface from your 10-day trial and you want to catch your breath, you've got to deal with these 25 other clients who you put on the sidelines while you're doing your trial. And there's no easy way to manage that kind of work, let alone deal with your family, your kids, your exercise, your health, and other things in your life while you're in the middle of it. It's hard work for anybody.
You know, one of the biggest problems we have in our profession is maintaining objectivity. And oftentimes you'll deal with opposing counsel who over-identify with their client, which causes all sorts of issues. How do each of you deal with opposing counsel who are too close to their client's case?
I'd have to say I've been fortunate There have been very few of those. They tend to be the people that behave that way all the time. So if you come across it, it's usually the same people, the same counsel colleagues that just can't help doing that, right? I've actually had a conversation with people where I've actually told them, look, this thing is it's getting too jacked up, okay? We have to sort of settle this thing down. And the only way that's going to happen is if both of us try and calm this thing down, okay? So I say that. And I had one occasion where I told the opposing counsel, I know you're getting really upset about this, but I can tell you, I'm not related to these people. I'm not going to get that upset about this because I'm not related to these people. It's not my personal problem. So I know we're in a difficult situation and I know that they're suffering, but it's not my personal problem. So if you want to get upset about it, that's fine, but I'm just not going to get that upset about it.
Jeffrey K., difficult opposing counsel because they over-identify with their client?
Well, I'm going to answer that question this way. And I know this isn't going to be that helpful for your viewing audience, but in my practice, at least for the past 20 years, I've been fortunate to deal with certain counsel. You, Jeff, Dinyar, others, who practice family law a certain way at a certain level. And I haven't had that many files recently where I've had to deal with opposing counsel who are irrational. I don't think there is, again, a magic way to deal with irrational counsel. I'll take a page out of your book, and Dinyar's book, frankly. What you would do often with other lawyers is you'd phone them up and you'd say, let's go for coffee. Let's go for lunch. Let's talk lawyer to lawyer without the clients and see if we can set down a framework for dealing with this problem. You've got a client, I've got a client. For all we know, they could have been reversed, but they're not. Let's see if we as lawyers can find a way forward that will mutually benefit our clients. So communication, respect, and trust among counsel is critical to assisting clients.
Jeff, you and I have discussed on a number of occasions the responsibility of counsel and the different levels of responsibility depending on the vulnerability or sophistication of the client. Can you discuss your concerns about our responsibility?
Yes, I can. It's something that's been on my mind. Acting for a sophisticated business person relieves a lot of counsel's burden because that person will understand their financial circumstances, they'll understand the values of what they have, they'll understand their income, they'll understand in a very sophisticated way the provisions of the Family Law Act, and they'll kind of know where they want to end up. So that relieves a lot of the burden of a lawyer. You still have your responsibilities, you still want to get things right, but acting for a sophisticated client is burden relieving. On the flip side, when you're acting for a vulnerable person who doesn't understand those things and is on the outside looking in, your responsibility is heightened because they'll say to you, I need your advice, I need your guidance, I need your help. And then it's no benefit to you to say, what do you want? Because often the response will be, I want what's fair, or I want what the law provides. But that's not a guide to you. And I've seen examples of lawyers who, in that situation, acting for a vulnerable person, take them down a path that is problematic. And it's the lawyer leading the client, not the client instructing the lawyer. And taking clients down that path is a huge responsibility because it's expensive, potentially. It's not necessarily a certain result. It's time-consuming. And it's more the lawyer leading the client. And that's perilous for the lawyer because the lawyer is then putting their view of the world and their view of what's right and wrong onto the client rather than receiving the client's instructions. And I've seen situations where lawyers have led clients on that path, not to the benefit of the client. So in acting for a vulnerable client, you've got to be very, very careful to explain to them cost, outcome, time, in order that they can better understand what they may be in for. And it's a huge responsibility for lawyers acting for a vulnerable client, and it can go wrong very quickly and very expensively. So it's a concern of mine.
Dinyar, anything you want to add to that?
You have to be firm also with clients, that there's some things you just can't do for them, and that maybe they can find, at some point you have to have the conversation. Maybe you can probably find some other lawyer that will do that for you. I won't, and it's not that I don't want to, because I don't think it's in your interests. I'm not going to do anything that I don't think is in your interests, whether you think it is or not.
Okay. What about responsibility of counsel again? What about responsibility of counsel when an offer comes in and you are the view that it's in the range of possible outcomes, but your client doesn't appreciate that? How do you deal with that?
Well, I think we have to go back to what Jeff's analysis involved. You have to tell them at some point, look, this is the offer. You've retained me to advise you, so I'm telling you, based on my experience, this offer is within the range of probable outcomes at trial. Okay? After you've spent all that money and stuff, this could be the result at trial. Now, it may be in the low end of the range, but it's in that range. So I put it to them this way. I say, look, I can't recommend that you just flat out stop negotiations or turn down an offer unless I can tell you with some confidence that if we go to trial, after you've spent all the money for preparing for trial and going to trial, and the aggravation and stress, you're still going to do better than that. Even after you've paid your legal bills, you're still going to do better than that. And I'd have to say it's pretty much a guarantee. In order for them to turn that down, or for you to advise them to turn that down, you have to be able to guarantee them that after everything else is paid for, they're going to do better, and not just better, substantially better, because they're not going to care if you got them an extra $5,000 after a 20-day trial. So that's kind of the analysis.
How far do you press? How much do you press?
Depends on how out there they are. Mm-hmm. So if they're kind of close to what you're saying, but they're just a bit out of the range, you can say, look, you want to go back, we'll make a counter offer, but then this offer's gone, there's a risk it won't come back, but you may still be able to come back with that one. But if they're way off it, I think you have to tell them, I just can't recommend you do anything other than come back to reality on this.
Okay. Jeffrey K., you want to add anything?
I think you have to press hard with your clients when discussing settlement. And it's in their interests that you do press hard, because you know as counsel what the road to trial and what trial looks like, and they don't. You know how stressful it is, you know how expensive it is, you know how acrimonious it can be. They don't know that. So if you're in negotiations, you have to press your clients hard to look at reasonable offers. You may not get everything, but you don't in a negotiation. But if it's good enough, and if it's in the range, and if you avoid the risk and the expense and the acrimony, it's worth pressing. And I think that's the responsibility of counsel to do that. Having fights with your own client can be the most difficult, but it's the responsibility of counsel to do that, in my view.
On the other hand, the matter goes to trial. Both of you have done significant trial work over the years. If you had a single litigation tip for our young viewers out there, what would it be?
Well, I haven't done a lot of trial work recently because my practice has gone in a different way. But you're there to help the judge make the right decision. And judges want you to help them understand the law in order to make the right decision. And that's part of advocacy. So I think being straight up with the court is critical, making sure that you have all the relevant law before the court, even cases that might not necessarily help you, but if they're relevant, before the court, and making submissions that are credible and can be accepted, as opposed to outlandish, overly aggressive, unrealistic submissions, which will hurt you. So credibility with the court is essential, in my view.
Any tips, Mr. Marzban?
I'd say two. So if we're talking about just trials, I would say before you ask any question on cross-examination, ask yourself, are you sure that the answer you're going to get is going to improve the evidence for your client? And if you're not, think really hard about whether you want to ask that question. General tip, and I've lectured about this before, but I think it's important, is chambers orders. So you go to chambers and maybe your client's there and you do this application. At the end of it, the judge gives oral reasons and it's a big win for you, and you leave and your client's really thrilled. And then you go back to your office and you draft the order and you send it to your friend for approval. And then your friend emails you back or writes you back and says, I don't agree with the form of your order. I don't think the judge said this. I think the judge said that, or qualified this, or didn't really address that. And you get into a letter writing campaign about that. So of course, that's a disaster because you can't enforce the order. So something like support, you can't send it to FMEP, anything. It doesn't even have to be a family case. The order's not entered. It's effective on pronouncement, but really, it's not really effective until you've got an entered order. So here's my tip, number one tip in litigation. If you're in chambers, you finish the application, you write down everything the judge says in his or her reasons, and then at the end of it, you wait to see if your friend has anything to say. If your friend doesn't, you stand up and you make sure you're the last person speaking. And this isn't the time to be shy or afraid or thinking the judge is going to say, why are you taking up more of my time? Or counsel sitting behind you saying, yeah, he's already explained that, why are you doing this? No. You stand up and you say, Justice, just so we're clear, my understanding is you've made the following orders. Bang, 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 in detail, right? Because you were writing those down as the judge was speaking. The judge will either say yes or no. If your friend has a problem, now's the time for your friend to speak up. And when you do this, it's going to give the court clerk a chance, the registrar, to write down your version of the order in the clerk's notes. Because often what happens is the clerk's just too busy. People are handing the clerk up notes while they're doing this. The phone's ringing and they'll scramble and try and write down something. As often as not, some of it will not be accurate, right? So this is a way to avoid difficulties entering orders because, as we all know, what do you do when you can't get the order? You have to take out an appointment with the registrar. So you tell your client this, and Jeff and I had a little laugh about this some time ago. You tell your client this. You just imagine this conversation. Say, yeah, I haven't got the order entered. And the client says, well, what's the problem? He says, well, you know, the judge, we wrote down the reasons I drafted the order, but the other lawyer says that this wasn't what was said. And the client says, well, I was there. That's exactly what he said. And I said, yeah, I know, but I still need them to sign the order. I said, okay, so what do we do next? He says, well, I have to take out an appointment with the registrar. So the client will normally think, was the registrar the person that was sitting below the judge making notes? I said, no, that was the court clerk. So the reaction is, who the hell is the registrar, right?
And how much is this going to cost me?
Yes, and the registrar, well, where's the registrar? I said, well, the registrar wasn't there. The registrar was in their office, probably downstairs, or might have been on vacation, or might have been at another courthouse, and we have to go see this person, and they're going to tell us what the judge said. So you can avoid all of that by just standing up at the end, make sure you're the last person speaking, and carefully go through all the details of the order. That's my tip.
Okay. You know, normally during the last couple shows, I've had artificial intelligence questions generated by artificial. You're looking at me as if I'm not modern. I'm very modern, Jeffrey. So today we have something else for you. And we're going to put something on the screen now, and then I'm going to ask you a question, okay? If I could. Okay. This question comes from Stephanie Fabro. And the question is...
Okay, I'm leaving now.
Yeah. Mr. Marzban also knows that the other half of the picture I cut out.
Yes.
Okay. Gentlemen, what advice would you give your younger selves looking back at your career?
Oh my God. I was never that serious. I think...
Remember, this is from Stephanie Fabro, so you can
Yeah.
get mad at her for this question.
I think that, like a lot of young lawyers, I was probably overly aggressive and not quite as sure of myself as I thought I should be. And when you're overly aggressive and you're a little bit insecure, it's a bad combination. So if I could go back in time, I would have realized that dealing with lawyers on the other side of a case in an open, respectful, confident way serves your client far better. And being overly aggressive, perhaps fueled by a bit of insecurity as a young lawyer, doesn't do anybody any good. So if I could go back in time, I would adjust the way I dealt with opposing counsel in a more conciliatory, open way.
Dinyar?
A bit of a take on what Jeff says there. I would say don't take things personally. That causes a lot of the problems. Some of it is the interaction with clients, but just don't take personally. You have to have a thick skin, and don't react to what you view as being slights, particularly from colleagues sometimes. You just have to let that go. You just have to let that go and treat them just like everybody else.
Right.
So that took a while.
Right. What does a good family law day look like? When
This.
you leave the office and you say to yourself, that was a good family law day.
I settled a mediation. Easy.
Okay? That makes you feel good?
Oh, great.
Okay. To go through the settlement line by line afterwards to make sure everybody's on the same page?
Oh, they've signed it. I leave, and it's like a weight taken off everybody's chest, and it's a great feeling.
All right, Jeffrey K., what's a good family law day?
A good family law day is meeting with a client, potentially a new client, where you know you're communicating well, where you're listening to them, they're listening to you, they're understanding what you're saying, you're understanding what their view of the world is, and you come to an understanding as to how you're going to go forward in a meaningful way. And at the end of the meeting, there's just a feeling that that was a good session. You know what you're doing, they understand that. They're someone that you want to act for, that you can work with, and you go forward. That to me is a good family law
So
day.
if that's in the morning, you just leave and get the hell out of the office for the rest of the day?
I go and have lunch with Mr. Marsban.
Okay. So gentlemen, I have some rapid fire questions. I hope you don't mind, okay?
I'm not promising I'll answer,
Okay.
but sure, go ahead. Yeah.
If you weren't a lawyer, what would you be?
In the realistic world or in the fantasy world?
In the realistic world.
I would be a journalist or a newscaster.
Okay. Dinyar?
Probably an unpublished author.
Okay. What was your worst subject at school?
Law school or generally school?
Generally school.
That's easy for me. Physics and chemistry. Physics and chemistry without question.
Okay.
I'd say physics. Chemistry, not too bad, but physics,
Yeah, we've talked about this on many occasions. What's your favorite Netflix or other streaming service series right now?
Well, I actually love watching series, more than movies now, and I often recommend them to my friend, Mr. Marzban. So I watched a series called A Spy Among Friends, which was the story about Kim Philby. It was a British production starring Damian Lewis that I thought was excellent.
Don't say Fauda. What would you say, Dinyar?
You know, I haven't found anything new. I haven't had a chance to watch the one that Jeff recommended. So, I watched some older ones that I hadn't watched before. And my favorite one actually was one Jeff recommended to me, which was The Wire.
Okay.
And I could watch that all over again. It's just a terrific, very sad, very poignant, appeared quite very realistic and gripping.
Okay. If you were to devote the rest of your life to philanthropy, what cause would you choose?
Something to do with children who are either impoverished or unwell.
I would say something environmental.
Okay. So what is it that most inspires each of you now, motivates you? Whatever it is in this world.
Oh, Dinyar?
You're talking professionally or just personally?
The world. In the world.
Mm-hmm. Yeah, it's still helping people. And with that, at this point in life, probably some measure of it is philanthropy, which can have a huge impact. So just directed philanthropy as opposed to just mailing a check somewhere. Directed, and a little bit can have a huge impact and can be life-saving for people.
Jeffrey K?
Difficult question. I'm going to answer it a slightly different way. I care deeply about my firm and the people that work at the firm, not just the lawyers, but everybody who works there. And I'm motivated to make sure that the firm stays strong. And I'm also motivated by my family. They motivate me to work hard and try as best I can to be a good person day to day.
And I'm sure each of your new grandchildren motivate you and inspire you, each of you.
No doubt.
Well, as I said at the beginning, this is a dream come true for me, having you both on the show and having practiced with you guys for so many years. So again, thank you very much. It's been a tremendous time. I'll see everybody else on Tuesday, April 4th. And some of our upcoming guests are Gordon Sloan, Carrie Boyle, and we are going to have the Chief Justice of the province on one of the shows. So thank you, everybody, for watching.
Jeff, can I just make a quick plug?
Remember
Do you mind?
Remember when we started the show, Dinyar, and you said to me, I told you that you're not in control? What happened?
Okay, I'm going to make a shameless plug here. So, family lawyers, as we know, we're all slammed. We're all slammed. There's just so much work and too much work for everybody. If you've been practicing family law for about 4 or 5 years and you want to join a firm in Vancouver, send me your resume, please.
That was a shameless plug.
That was a shameless plug. Well, there you go, everybody. Thank you again.
Thanks, Jeff.
Thank you.
Thanks.